The document reads like a receipt. A child, male, age 7, described as healthy and able-bodied, transferred from one household to another in exchange for the cancellation of a debt valued at $43. The transaction was witnessed, notarized, and filed with the county clerk. It was not hidden. It was not unusual. It went into a drawer with the other property records between a land transfer and a livestock sale, because in 1847, in at least 11 American states, that is exactly the legal category it belonged to. What you are looking at when you find these documents is not an aberration. It is a system. It has a name. It has a legal framework. It has a paper trail that runs through county courthouses across the eastern and midwestern United States, and most of the people whose family histories pass directly through it have never been told it existed. The system was called indenture, and the word carries enough historical distance now that it tends to land softly, like something that happened in another world to people who were essentially different from us. That distance is not accurate. Indentured labor in the American context of the mid-19th century was not the voluntary contract system that brought European immigrants to colonial America in the 1600s, where an adult agreed to work for a set period in exchange for passage and eventual freedom. By 1847, what operated under the legal umbrella of indenture in states including Ohio, Indiana, Illinois, Missouri, Kentucky, Virginia, Maryland, Pennsylvania, New York, New Jersey, and Delaware had evolved into something considerably more specific and considerably harder to look at directly. It was the legal transfer of children, overwhelmingly from poor families, orphaned households, or families that had fallen into debt, into the labor and custody of households that paid for them, held legal authority over them, and in most cases were under no binding obligation to educate them, compensate them, or release them at any fixed point. The contracts ran until age 21 for boys and age 18 for girls in the states that specified an end date at all. The economic context matters because it explains the scale. The 1840s in America were years of severe economic pressure following the Panic of 1837, a financial crisis that contracted credit, collapsed land values, and pushed enormous numbers of working families into conditions that made feeding every child in the household a genuine daily calculation. Irish immigration was surging following the onset of the Great Famine in 1845, flooding eastern port cities with families who had arrived with nothing and had no established community infrastructure to absorb them. Urban poverty in cities like New York, Philadelphia, and Baltimore in this period was not the background condition that later sanitized histories tend to imply. It was acute, visible, and producing outcomes that contemporary observers documented with a directness that is uncomfortable to read. Children worked in factories at ages that are now internationally recognized as child labor violations. Children slept in the streets in numbers large enough that city officials in New York estimated the population of unsheltered minors in the late 1840s at over 10,000. Into this context, the indenture system did not arrive as exploitation wearing a mask. It arrived as a solution, framed explicitly by its proponents as a mechanism for removing children from dangerous poverty and placing them in stable households where they would learn a trade, receive food and shelter, and emerge at the end of their contract as productive members of society. That framing was not entirely dishonest. It was also not the whole story. The legal architecture that made child indenture possible in 1847 was not a single federal statute. It was a patchwork of state poor laws, orphan court jurisdictions, and county-level administrative practices that had accumulated over decades without any coordinating principle beyond the assumption that children without adequate parental support were a public problem requiring a practical solution. In most states, the authority to indenture a child rested with local overseers of the poor, appointed officials whose job was to manage the indigent population of their county with whatever resources the county budget provided. An overseer could legally bind out a child whose parents were deemed unable to support them, and the threshold for that determination was entirely at the overseer's discretion. A father in debt, a mother widowed, a family that had missed rent, any of these could trigger a proceeding that ended with a child being assigned to another household, with or without the parents' consent, and with no requirement that the parents be notified of where the child had gone. The contracts themselves, when they survive in county archives, are standardized documents with blank spaces for the relevant names, ages, and terms. The language is businesslike, The child is referred to throughout as the apprentice or the bound child. The receiving household is referred to as the master. The master agrees to provide meat, drink, washing, lodging, and apparel suitable to the child's station, to teach or cause to be taught the trade or occupation of farming or housewifery depending on the child's sex, and in some contract versions, to provide schooling for a specified number of weeks per year, typically between 6 and 12. What the contracts do not specify is what happens if the master provides none of these things. The enforcement mechanism was the same overseer who had issued the contract, operating with the same discretionary authority, answerable to no one above the county level, and typically managing a caseload large enough that individual follow-up was practically impossible. The records that document what actually happened inside these arrangements come from 3 sources: the rare court cases where conditions became severe enough that a complaint was filed and survived in the legal record, the personal accounts written by individuals who had been indentured as children and recorded their experiences in letters, memoirs, or testimony before later reform commissions, and the death records that sometimes followed children into the households where they had been placed and sometimes did not. The court cases are the most disturbing because they reveal the floor of what the system permitted before intervention occurred. In Ohio in 1849, a case before the county orphan court documented a child of 9 who had been indentured 3 years earlier and was returned to court by neighbors who had observed conditions they considered unacceptable. The court record describes the child as malnourished and bearing marks consistent with regular physical punishment. The master was reprimanded. The indenture contract was transferred to a different household. The child did not leave the system. The system had no mechanism for that outcome. The racial dimension of child indenture in this period operated on a separate and more brutal track. In states where slavery remained legal, free black children occupied a legal position so precarious that the line between indenture and enslavement was in practice almost non-existent. Several southern states had statutes explicitly permitting the indenture of free black children without parental consent and without specified end dates, effectively creating a parallel system of bound labor that slavery's defenders could point to as evidence that the condition of black Americans did not depend on the formal institution of slavery to perpetuate itself. In Maryland, free black children were indentured at rates that contemporary reformers documented as disproportionate by any measure, with county overseers systematically binding out children from free black families while exercising far more restraint with white families in comparable economic circumstances. The reform movement that eventually dismantled child indenture as a legal system did not arrive quickly or cleanly. It came in stages, driven by a combination of forces that did not always agree on why the system was wrong or what should replace it. Charles Loring Brace, who founded the Children's Aid Society in New York in 1853, believed that the solution to urban child poverty was removal, not indenture exactly, but the mass relocation of city children to rural households in the Midwest and West, where, he argued, the wholesome influence of farm life and Protestant family structure would rehabilitate them. The orphan trains that operated under this philosophy between 1854 and 1929 transported an estimated 250,000 children from eastern cities to receiving families across the country. The program was not indenture in the legal sense. The children were not contracted, but the practical experience for many of them was not meaningfully different. Placed with strangers, expected to work, separated from siblings, with no reliable mechanism for complaint or return if the placement went badly, Brace genuinely believed he was helping. The children who later wrote about their experience were divided, some describing the families they found as genuinely warm and the opportunity as real, others describing years of labor under conditions that differed from formal indenture primarily in the absence of paperwork. The legal abolition of child indenture proceeded state by state through the second half of the 19th century, driven largely by the labor movement, which objected to bound child labor as a form of unfair competition with adult wage workers, and by the emerging child welfare movement, which was beginning to articulate the idea that children had interests that the state had an obligation to protect rather than simply manage. Illinois abolished the practice in 1867. Ohio followed in 1874. New York's reforms came incrementally through the 1870s and 1880s. The last formal legal frameworks permitting traditional child indenture were not struck from American law until the early 20th century, and the practical conditions that had made the system possible, acute child poverty, inadequate public support infrastructure, discretionary authority concentrated in local officials with no accountability, did not disappear with the statutes. They shifted into different institutional forms: the reform school, the orphanage, the state industrial school, each of which reproduced aspects of the indenture system's logic while presenting a different public face. The county courthouses where the original contracts were filed still exist. The documents are still there in many cases, in the deed books and orphan court records and overseer of the poor ledgers that local historical societies and state archives have been slowly digitizing for decades. If you know where to look and what you are looking at, you can find the receipts. A child transferred for a debt. A 7-year-old recorded between a land sale and a livestock transfer. The transaction witnessed, notarized, filed. The child's name in the record. The master's name. The amount. And then silence, because what happened after the filing is almost never in the same folder, and the child does not appear again in the documentary record until they are old enough to have generated their own paperwork, if they survive long enough to do that. If a detail in this video landed on you differently than you expected, the overseer with no accountability, the contracts with blank spaces, the children who never appeared in the record again, tell us which one in the comments. Not a reaction, the actual moment. And if your own family research has ever hit a wall in this period, especially in the states we named, share what you found, or what you couldn't find. This community reads those threads and they matter more than you think. If you want to be here when we keep going, subscribing is 2 seconds. We are building something here for the people who refuse to look away. You are clearly one of them. Come back.